Hey folks, welcome to Role of Law. Today I want to answer a question a lot of you have been asking, and that is, did Wizards of the Coast accidentally give away the Beholder and Mind Flayers and Strahd Von Zarovich and a bunch of other things by putting them under a Creative Commons license? Now I'm going to start with the answer and then go on to the lengthy explanation. And the answer is no, except, or yes, but maybe not in the way that you'd like. And so I know those are unsatisfying lawyerly answers, so I'm going to give you the full sort of background here. I'm also going to start off with the caution of I am a lawyer, but I'm not your lawyer. Rules differ from varying jurisdictions, and so if you're sitting there watching this because you're thinking of starting a new game system, maybe you're going to call it Trail Locator or something, you should really talk to a lawyer and not just watch a YouTube video, because going into court and saying, I got the law wrong because I watched a YouTube video is a great way to get laughed at in court. Okay, so let's start off by explaining the issue here, because a lot of people are probably going, what is this gray-haired guy yammering about? And that's fair. So, Wizards of the Coast owns intellectual property in a bunch of different things, including the Beholder. And in fact, the Beholder is probably, at least in the sense of monsters, the most iconic Wizards of the Coast IP. You might say, why not dragons? Like, dragons are right there in the name. They get title recognition, so shouldn't it be dragons? Problem is that dragons predate Wizards of the Coast and TSR and chainmail and tabletop role-playing games entirely. Dragons are largely drawn from cultural and mythological backgrounds. There's myths about dragons in a variety of different cultures, and all of the essential bits of dragonness really come from that and not from wizards. So they can't own that concept. Whereas if we get into beholders, beholders are sort of a Dungeons and Dragons monster. That's where they come from, and they've been in every edition of Dungeons and Dragons, and they have a rich and detailed lore that is specific to that. So Wizards is better able to own intellectual property in that sort of concept than they are in, dragons or kobolds or various other things. Now, that doesn't mean that they own every aspect of beholders or the ability to control every discussion of them. Certainly, I've probably used the word beholder like 40 times now. But there's some things that you can do and some things that you can't. And we can draw a comparison between that and Batman. Now, I've just mentioned Batman, but I don't own the Batman IP. I'd really like to. I mean, if you're thinking of what can I get, Ian for Christmas, and you're thinking, I will get him the Batman IP, that would be a fantastic gift. But I don't see it happening. So I can't write a Batman comic book or a Batman movie or anything like that. But if I was writing a modern novel, it's set sort of in the modern era, and one character sneaks up on another and surprises them, and the second character is like, who is that? And the first character makes a joke saying, I'm Batman. Well, that is probably not going to be an issue. This is a reference to something in the culture. I'm not sort of appropriating that character in any fashion, so that's probably fine. By the same token, if I mention beholders in this video, I'm probably not going to get any sort of issue. But if I were to instead publish a book that is a really deep dive into beholder ecology, then I might get somebody, terrifying like this person. I know she doesn't look like much, but I guarantee you she can probably write a cease and desist that will make your ears bleed, sending me a very nasty letter. So that sort of is a restriction on what you can do. Now, previously, people were relying on the Open Gaming License version 1.0a, and that actually included some additional restrictions, some that went even further. So let's have a look at that, because this is really important to understand what's changed so that we can understand what we can and can't do now. All right, so that has this little clause here. The following items are designated product identity as defined in Section 1E of the Open Game License, and are subject to the conditions set forth in Section 7 of the OGL. This is going to be important. And are not open content. And that includes things like Dungeons & Dragons, D&D, Player's Handbook, Dungeon Master, Monster Manual, D20 System, Wizards of the Coast, D20, Forgotten Realms, and then I'm going to skip over a whole lot of those, although I will mention one aspect: proper names, including those used in the names of spells or items. So Strahd Von Zarovich would be an example. Melf, Tensor, Tasha, all of those names would be something that they call product identity. And then carrying on to things like Beholders and Mind Flayers, Illithids, Umberhulks, Yuan-Ti. So lots of things that they designate as product identity. Well, what does that mean in this context? Well, if we scroll down to Section 7, use of product identity. You agree not to use any product identity, including as an indication as to compatibility, except as expressly licensed in another independent agreement with the owner of each element of that product identity. You agree not to indicate compatibility or co-adaptability with any trademark or registered trademark in conjunction with a work containing open game content, except as expressly licensed in another independent agreement with the owner of such trademark or registered trademark. The use of any product identity in open game content does not constitute a challenge to the ownership of that product identity. The owner of any product identity used in open game content shall retain all rights, title, and interest in and to that product identity. Okay, that's a mouthful, right? Sorry to have to read that to you, but it's important to look at what we're dealing with here. So as part of the agreement for the OGL 1.0a, you agree not to use this product identity at all, including in ways that you would otherwise be permitted to. For instance, you agree not to indicate compatibility or co-adaptability with any trademark, which includes Dungeons & Dragons. So you can't, if you're using the OGL 1.0a, say this product is compatible with Dungeons & Dragons 5th edition. Now, normally that would actually be a permitted use in many cases, and this gets complicated. This is another place where I'm putting a big talk to a lawyer, because there's various ways to screw this up and get yourself the nasty letter from this person. This is a stock image. It's not actually Wizard's lawyer. I should make that clear. But this is a thing that you normally can indicate. So for instance, if you are making car parts, you might not be, Honda, but you might design some sort of aftermarket, I don't know, radio or whatever, and say that it's compatible with the Honda Civic. Normally that's protected as a fair use of, the trademark. We're going to get into a little bit into the weeds, but the important aspect here is that you give that up by agreeing to OGL 1.0a. So even if otherwise you could mention Beholders in the way that I sort of talked about, you can't once you're relying on the OGL. So the equivalent is, I can't have my character mention Batman even though my character isn't Batman, right? All right, now you might be saying, what happens if I do so anyway? Well, there's a wonderful provision here, termination. This license will terminate automatically if you fail to comply with all terms herein and fail to cure such breach within 30 days of becoming aware of the breach. All sublicenses shall survive the termination of this license, which means if you go ahead and include those terms in your OGL 1.0a content, your license ceases to exist and you can get sued, which is not fun. All right, so that is sort of where we start. However, now Wizards of the Coast goes and makes a giant PR blunder. They really, really stepped in it, and everybody and their dog on the internet, myself included, was calling them out for it and was really ripping into them because they deserved it. And as part of their public walkback of that, as they eventually realized that they had essentially declared war with their fan base, they said, not only are we going to keep the OGL 1.0a forever, but we're also going to release the SRD under a Creative Commons license. And so now there are two licenses available, and not just one. And importantly, the Creative Commons terms don't include like beholder as a, as something that will kill your license. All right, you're saying, great, I can do all sorts of things with this. I've got big plans. Well, slow your roll, because the things you can do with it are going to be fairly limited. Let's talk about what is actually in the SRD about beholders specifically, and they're just an example. All right, so we've got a couple of entries. Aside from the actual legal text, there's basically one magic item that mentions beholders, that it can create an illusion of one. But there's also this block here talking about aberrations. Aberrations are utterly alien beings. Many of them are innate, or have innate magical abilities drawn from the creature's alien mind rather than the mystical forces of the world. The quintessential aberrations are aboleths, beholders, mind flayers, and slotty. So that's sort of a paragraph there. What you'll note here is that it doesn't include any of the sort of deep beholder lore. Like when we talk about beholder culture, and I call it beholder culture, even though beholder culture is mostly just they hate each other, and so they don't really have a shared culture other than just hating each other and everything else. So, that aspect, or beholders not sort of reproducing in the standard fashion because they can't even stand to be near each other enough to get it on, but instead new beholders coming because some previous beholder had a bad dream and dreamed of a different beholder, and that's always a bad dream for a beholder. And then that creates this new beholder. Like, all of that stuff is not in here. So if you wanted to write a book that was a deep dive into the ecology of the beholder, you're probably stepping into areas that Wizards of the Coast may very well have a very valid claim on. And again, you get her writing the cease and desist that will make your ears bleed. So we don't want to do that. Similarly, you might be able to have somebody mention Strahd Von Zarovich, but you wouldn't be able to write an adventure that features Strahd as a character. For instance, if you wanted to have an adventure where you travel back in time and try to kill Strahd in his early 20s with lasers and mechs and whatever else, that would probably be a no-go. So you might be saying, okay, well, that's not very satisfying. There might be some circumstances where you want to quote that paragraph on aberrations, but probably not a whole lot. And quite frankly, you can probably quote it without the Creative Commons license. I just did. Come at me, Wizards. But I think that's sort of within fair dealing if you're quoting it, because it's a small piece. But again, talk to a lawyer if you're looking at doing this. I'm running my own risks making this video. You got to choose yours, and you should do so in an informed way. All right. So what can you do now that you couldn't before? Is there any sort of interesting applications? And again, you should talk to a lawyer before you do any of these things, because I run my risks, you run yours. Not legal advice. Do not rely on this. If you try to sue me because you relied on this, I'm going to point to this portion of the video and mock you extensively. All right, but let's look at some of the interesting things that we see. So, Acid Arrow is a spell that is detailed in the SRD, and it's Acid Arrow, second level evocation. It tells you all the stuff it does. And if you break out your player's handbook, you will not find Acid Arrow in that book, because you're going to find it as Melf's Acid Arrow. If you were relying on the OGL 1.0a, there was no way to call this Melf's Acid Arrow, which creates some problems because you end up putting in your monster stat block that it casts Acid Arrow, and somebody trying to look it up finds it under Melf. That's obnoxious to the player. Now I think you could probably, and again, I say probably because risk is a thing in law and indeterminacy, but say, the monster can cast Melf's Acid Arrow as cited to a particular page in the player's handbook. That wouldn't be a breach of the Creative Commons license, and is probably, and again, probably is a load-bearing word when lawyers use it, something that would be covered under fair use, fair dealing, as just a reference to a particular item. Now, I think that's pretty cool. I think that opens up a lot of stuff that you couldn't do before. And I think that's important. So, to sort of wrap this up here, I've seen a lot of articles talking about, oh, you can do whatever you want now with Strahd Von Zarovich. And don't. That's a really dangerous thing. But there's certainly some things that have been opened up by not needing to rely on the OGL. This isn't so much that it's new powers given to you by Creative Commons, so much as it's new powers given to you by removing some of the old restrictions that existed under the OGL. All right. I know this is probably an unsatisfying answer because that's what lawyers do. We give you unsatisfying, complicated answers to difficult questions. Oh well. Again, this is an area that I will describe as legally hazardous. If you are writing a book and you want to use any of those things that they identify in the SRD as being product identity, you've got to realize that this is what Wizards of the Coast considers the crown jewels, right? This is, or maybe even a step further, they might consider these the family jewels rather than the crown jewels. So if you start poking around there, you can expect that they might get a little spicy with you and a little irritable with you. And irritable when you're talking about big corporations typically means lawyers and thousands of dollars in expenses. So tread very carefully. Again, I've said it several times in this video. I'm going to say it again. Talk to a lawyer if you're looking at doing any of this stuff. I can guarantee you, there's a fundamental rule of lawyers, which is we get more expensive the more you don't call us. And what I mean by that is that the cost to get a legal opinion at the beginning of when you're doing a book is way cheaper than the cost of fighting over that legal opinion you didn't get when you ultimately end up in a legal battle. Lots of people find this out in the context of contracts. They start a business with their brother over a handshake and a beer. And later that relationship falls apart and it turns out that the litigation over that is super expensive. Or wills, I don't need a will. I can just do this on the back of a napkin or a tractor bumper or whatever happens to be around, if holograph wills are legal in your area, which is a big maybe. And then later when that ends up being challenged in court, it's super expensive. So this is really a place to lawyer first, make mistakes afterwards. Anyway, I hope I've clarified this and sort of explained what some of these articles are referring to and what's going on. Please let me know in the comments what you're thinking or, what your thoughts are, because if you still got questions, I'd like to try to answer them and clear this thing up. But yeah, that's sort of something I wanted to talk about. I'm thinking my next video, I'm going to talk a little bit about world building, because that's more fun than this. So anyway, see you guys next time. Thank you for joining me, and please, if you could, do all the YouTube things. YouTube's got a whole bunch of buttons down there, and just hit all of them. Leave comments, just slam buttons. That's fantastic. All right, thank you very much.